following case treats about Bear Creek Mining Corporation versus the state of Peru. This case was analyzed by the International Center for Settlement of Investment Disputes, also known as the ICSID. It will be presented by Julian Rodriguez, Lopera, and Sara, Cadena, which are members of Group 6 of the International Public Law class from the University of Rosario.
Facts. The plaintiff, Bear Creek Mining Corporation, is a Canadian company that in the year 2004 was interested in investing on the development of the Santa Ana silver mine, located in the region of Puno, Peru. Under Peruvian jurisdiction, every natural resource near a border is property of the state. However, there is an exception. Peruvian officials can authorize a private individual to exploit and plunder a natural resource by a supreme decree. Such decree was given by Ms. Lopez to representatives of Bear Creek Mining, and after it was revoked by the 083/2011 decree by the executive branch. Also, the state argued the Bear Creek Mining Co. did not hire any Peruvian employee for the project, and the company was never granted a social license to exercise in the terrain because the community never settled with the company. Given the fact the mine is located 50 kilometers from the border with Bolivia, a specific authorization from the executive branch of Peru is required for any investor to operate, following Article 71 of the Peruvian Constitution. In order to maintain its demand in Santa Ana, Bear Creek first had a Peruvian employee register the relevant mining rights. He then requested and received the necessary authorization to acquire said rights in his name. Later, in November 2007, through Supreme Decree 083/2007, Bear Creek obtained authorization to acquire, own, and operate the corresponding mining concessions. Between 2007 and 2011, Bear Creek secured financing for the development of the Santa Ana mine. According to the company, it had proposed a sustainable design for the mine, as evidenced by the government's approval of the impact report in 2011. They also claimed that the meetings public with the local residents had had a lot of participation and generated mostly favorable returns. However, local communities strongly opposed the development of the Santa Ana mine through violent protests. The concerns of the local population were that the mining activity of Bear Creek would negatively affect their land and thereby their cultural identity. In June 2011, the newly elected government, in an attempt to deal with the social unrest in the Puno region, issued Supreme Decree 032/2011, which revoked Supreme Decree 083. Decree 032 had the effect of chartering the mining project. In August 2014, Bear Creek filed a request for arbitration at the International Center for Settlement of Investment Disputes, (EXIT). Under Article 832 of the FTA, Canada submitted a non-disputing brief. The court also received 3 requests to submit a written communication as amicus curiae, but accepted only 2.
Issue. First, did Peru commit an indirect expropriation against Bear Creek Mining Corporation? Second, did the claimant realize the actions required by the state for obtaining a social license?
So according to the first question, yes, there was an indirect expropriation because of the economic impact caused by the decision to the investment. Second, in reason of the character of the series of measures, this one, according to Peru, could not be accepted if there is good faith, non-discriminatory measures for the public well-being and for the safety of the environment. The second problem regarded that local communities never agreed, and therefore there was no social license, so there wasn't an authorization. Given the fact that there was a social unrest, the Peruvian government had to throw back and quit the treaty between both parties.
So the final decisions of the tribunal were the default or omission, which the state of Peru actually accused the enterprise of making it. They needed to prove it with the harm caused by the community. According to the Bear Creek Mining Corporation, the revoked Decree 083 of the 2007 and replaced by the Decree 032 of the 2011, constituted an indirect expropriation according to the Article 812 of the Free Trade Agreement FTA between Peru and Canada. It is important to highlight why there was the indirect expropriation according to the tribunal. So first, it was because the economic impact caused by the state, because the reasonable expectations of the investors were not realized, and third, because the rights acquired before by the investors were revoked. On the other hand, the fair and equitable treatment, the unreasonable and discriminatory measures, and the full protection and security was not granted by the tribunal. It was argued by the state of Peru that the Bear Creek Mining Company had done these actions, but the tribunal said they were not need to be analyzed. The tribunal argued that actually the company had fulfilled all the requirements. Also, on the other hand, they argued that there was not a due process granted by the state of Peru. The company was totally blocked from the decision. The tribunal stated, according to the damages, that the state of Peru should pay a compensation for the actions realized. So the final decision of the tribunal was, first, that the court has jurisdiction over the claims raised. Second, that the respondent must pay claimant $18,237,592 in concept of compensation. 3. That the respondent must bear its own cost of the arbitration and reimburse the claimants for 75% of the arbitration process costs, which means $5,986,183. 4. There must be a rate of the 5% of the capitalized interest over the compensation payment since the date of the publishment of the Decree 083 of the 2011, and over the arbitrary cost since the date of this award. And finally, 5. All other claims are dismissed.